In this video, we are going to see the definition and meaning of the delegated legislation. We are also going to see how it differs from primary legislation. Delegation means to give power or to give authority. Generally, delegation of power is from higher authority to the lower authority. According to the Black's Law Dictionary, delegation is an act of entrusting another with an authority or empowering another to act as an agent or representative. Simple example of delegation is delegation of contractual duties. In administrative law, we are going to see the delegation of legislative power, that is the power given by legislatives to executive. Now let us move to the term delegated legislation. According to C.K. Takwani, delegated legislation is a legislation made by a body or a person other than the sovereign in the parliament by virtue of powers conferred by such sovereign under the statute. Hence, when the function of legislation is entrusted to the organs other than the legislature by the legislature itself, the legislation made by such organ is called as delegated legislation. As far as the function of making of laws is concerned, it is given to the state legislature and the parliament. Means legislative authorities are higher authorities in case of making of laws. When these higher authorities confers the power of making of laws to the lower authorities, means executives, then delegated legislation is formed by them. Now let us see the examples of delegated legislation. The Advocates Act 1961 is the act made by the Parliament. The act empowered Bar Council of India to make rules on professional standards and for also discharging its functions under the act. Under the Motor Vehicles Act 1988, the central and state governments are empowered to make rules for the purpose of the act. Then the Minimum Wages Act 1948. The object of this act is to provide for fixing minimum wages in certain employments. This act applies to the employments mentioned in the schedule, but the central government, which is the executive, is empowered to add any other employment to the schedule. When we talk about the nature of the delegated legislation, we must go through the theory of supreme and subordinate legislation given by Salmond. According to this theory, legislation is either supreme or subordinate. Supreme legislation proceeds from the sovereign or superior power, and subordinate legislation flows from any authority other than the sovereign power. This legislation depends for its existence and continuation on superior or supreme authority. Then, according to Halsbury Laws of England, when an instrument of legislative nature is made by an authority in exercise of power delegated or conferred by the legislature, it is called as a subordinate legislation. In short, we may say that according to Halsbury Laws of England, delegated legislation is subordinate legislation. According to MP and S.N. Jain, the term delegated legislation is used in two senses. First, it is the exercise of legislative power by a subordinate agency. This legislative power is delegated to the subordinate agency by the legislature itself. It means that the authority making the legislation is subordinate to legislature. In the second sense, the term delegated legislation is used as the subsidiary rules themselves which are made by the subordinate authority in pursuance of the power conferred on it by the legislature. Thus, all these opinions say that the delegated legislation is the subordinate legislation. Delegated legislation is also referred as secondary legislation, subsidiary, ancillary, auxiliary, administrative, or quasi-legislation. Now let us see how the delegated legislation differs from the primary legislation. The law made by the legislature, that means parliament or state legislature, is called as a primary legislation, while the delegated legislation is the law made by the executive authorities under the power given to them by a legislature itself in order to implement or administer the requirements of that primary legislation. In modern times, it is not always possible for the legislatures to make laws providing every details. Also, in the view of new emerging areas, lawmaking today has become not only time consuming but also an increasing complex and technical affair. Hence, the legislature can lay down the policy and purpose of the legislation and leave it to the executives, experts to provide for the working details within the framework of the enactment by the way of rules, regulations, bylaws, and other statutory instruments. Thus, we may say that primary legislation creates framework, lays down outline, policy, and purpose of the enactment, while the delegated legislation provides working details, guidelines, rules, regulations, bylaws, or other statutory instruments within its limit or in accordance with the corresponding primary legislation. It is important to note that delegated legislation is just supporting in nature. It cannot replace or modify the parent law or the primary legislation, and such an attempt is struck down in the court of law for being ultra vires. Now let us see how the delegated legislation is criticized. According to Justice P.P. Mukherjee, delegated legislation is an expression which covered a multitude of confusion. He viewed delegated legislation as an excuse for legislature. It is a shield for executors, while a provocation to the constitutional jurist. Traditional thinkers did not favor delegation of the legislative power to the executives. According to them, delegation is a bit of encroachment of power. Wade and Forsyth, in their famous work Administrative Law, stated that administrative legislation is traditionally looked upon as a necessary evil. It is unfortunate but inevitable infringement of the separation of powers. As there is only a hazy borderline between the legislation and administration, the assumption that the legislative power and administrative powers are different forms of powers is misleading. At the end, we may conclude that the legislative power is the power to lay down the law for people in general, while administrative power is the power to apply the law for the people in some particular situations. One of the most significant developments of the present century in the field of law and public administration is the growth of legislative powers of the executives in the form of delegated legislation. Though delegated legislation has a widespread practice in modern times, we may see the contrary views also.